This video is not legal advice. It is for educational purposes only. It does not create an attorney-client relationship. Always consult a qualified attorney for advice specific to your situation.
The general concepts of jurisdiction, venue, and forum assume distinct, court-specific applications depending on whether a federal or a California state court is concerned. In the federal court system, jurisdiction and venue are determined by the United States Constitution, federal statutes, and interpretive case law, not the federal rules of civil procedure. By their own terms, the federal rules of civil procedure neither extend nor limit the jurisdiction or venue of the federal courts. The rules govern only the orderly conduct of litigation once a case is properly before the court. Beginning with the apex federal court, the Supreme Court of the United States derives its subject matter jurisdiction from Article 3, Section 2 of the United States Constitution and from Sections 1251 through 1257 of Title 28 of the United States Code. The subject matter jurisdiction of the Supreme Court encompasses constitutional disputes, cases arising under federal law, controversies between states, and diplomatic matters. As the highest national court, the Supreme Court does not labor under individual state boundaries. Its constitutional status permits nationwide service of process under the Fifth Amendment and concomitant personal jurisdiction, which is a sovereign power it shares with inferior federal courts, though those lower courts are generally restrained by procedural rules. The United States Supreme Court holds original and exclusive jurisdiction over controversies between two or more states per Section 1251 of Title 28 of the United States Code. Such disputes cannot be tried elsewhere. In these rare cases, the court sits as a trial court and routinely appoints a special master to develop the evidentiary record, particularly in matters involving interstate boundaries or water allocations. It also possesses original but concurrent jurisdiction over actions involving foreign diplomats, controversies between the United States and a state, and suits by a state against citizens of another state or against aliens, as provided in Section 1251. The United States Supreme Court exercises appellate jurisdiction, primarily by writ of certiorari, over decisions of the federal courts of appeals, the highest courts of the states, and certain military courts, including the Court of Appeals for the Armed Forces, provided a federal question is presented. This authority appears in Sections 1254, 1257, and 1259 of Title 28 of the United States Code. Where a matter coming from a state court concerns only questions of state law, nothing exists for the Supreme Court to review. Hierarchically below the United States Supreme Court are the federal courts of appeals, commonly known as the circuit courts. They derive their authority from Article 3 and exercise jurisdiction principally as set forth in Sections 1291 through 1295 of Title 28 of the United States Code. These courts predominantly review lower court decisions for legal error. Cases do not typically originate before them. Accordingly, the circuit courts exercise no general original jurisdiction, save for limited exceptions involving certain writs or specific statutory grants. They hear appeals, as of right, from final decisions of the district courts within their respective circuits, along with certain interlocutory appeals authorized by statute, and review decisions from various federal administrative agencies. Because the circuit courts sit in review of district court proceedings, they have no independent diversity of citizenship requirement. Their appellate subject matter jurisdiction encompasses lower court cases arising out of the United States Constitution, federal statutes, or treaties. Personal jurisdiction over the litigants is established or challenged in the lower district court and carries forward on appeal, even when the circuit court is reviewing a ruling on personal jurisdiction itself. In most instances, the regional circuit courts hear appeals from the district courts within their geographic boundaries. The United States Court of Appeals for the Federal Circuit, however, exercises exclusive nationwide appellate jurisdiction over certain specialized matters, notably patent cases from district courts and appeals from specified administrative bodies. Because only the federal courts of appeals, and ultimately the Supreme Court, may review decisions of the federal district courts, and state courts possess no authority to do so. Such appellate jurisdiction is exclusive rather than concurrent with the states. Decisions of each circuit court constitute binding precedent only within the court's own circuit. At the base of the federal court hierarchy are the federal district courts. These are courts of original but limited jurisdiction. They possess subject matter jurisdiction over cases arising under federal law and over controversies between citizens of different states, where the amount in controversy exceeds $75,000. Federal question jurisdiction, therefore, does not reach common crimes, juvenile delinquency, traffic violations, ordinary personal injury actions, contract disputes, real estate matters, probate, or domestic relations cases. Diversity jurisdiction requires complete diversity of citizenship and the requisite amount in controversy. If a diversity case is initially filed in state court, a defendant may remove it to federal court, provided no properly joined defendant is a citizen of the forum state, with the removing party bearing the burden of establishing federal jurisdiction. Like state courts, federal district courts must possess personal jurisdiction over non-consenting defendants. Their personal jurisdiction does not, however, extend nationwide. Personal jurisdiction in district courts is generally delimited by the long-arm statutes and constitutional limits of the states in which they sit, as incorporated by Rule 4 sub K sub 1 sub A of the Federal Rules of Civil Procedure. All constitutional bases available to state courts: presence, consent, appearance, and purposeful availment through minimum contacts satisfying fair play and substantial justice, are therefore utilizable by federal district courts, supplemented in appropriate cases by specific federal statutes authorizing service of process. Federal district courts have original and limited jurisdiction chiefly over federal question and diversity of citizenship cases, while the federal courts of appeals and the United States Supreme Court have appellate jurisdiction over those same cases. However, as already noted, the federal district courts are only bound by the appellate jurisdiction of the courts of appeals within their circuit. Accordingly, the United States Court of Appeals for the Ninth Circuit, the federal circuit in which California finds itself, can only bind the decisions of federal district courts within the Ninth Circuit. It does not bind federal courts in other circuits, nor does it bind California state courts. Federal district courts possess exclusive jurisdiction over a wide range of federal matters, including admiralty, federal crimes, bankruptcy, most patent and copyright disputes, and many, but not all, cases involving the United States as a defendant. For most non-tort monetary claims against the federal government exceeding $10,000, exclusive jurisdiction lies with the United States Court of Federal Claims under the Tucker Act, which waives sovereign immunity for monetary claims against the U.S. government founded on the Constitution, federal statutes, regulations, or contracts. When a case over which federal courts have exclusive jurisdiction is filed in state court, the defense may remove it to federal court by filing a notice of removal. Upon proper removal, the state court's jurisdiction is suspended, subject to remand if the federal court finds a procedural defect or a lack of federal subject matter jurisdiction. As for venue within the federal court system, the rules are more restrictive than those of many states. Under Section 1391 of Title 28 of the United States Code, a civil action, whether based on diversity or a federal question, may generally be brought in a judicial district where any defendant resides, if all defendants reside in the same state, or where a substantial part of the events or omissions giving rise to the claim occurred. Corporate defendants, however, are deemed to reside in any district in which they are subject to personal jurisdiction with respect to the action in question. These rules are supplemented by specific venue statutes for certain types of actions. Concerning forum selection, Federal practice is less restrictive than many state regimes because of the broad statutory authority to transfer cases from one district to another for the convenience of parties and witnesses, or in the interest of justice. Finally, regarding choice of law, federal district courts always apply their own procedural rules, but under the doctrine of Erie Railroad Company versus Tompkins and its progeny, must apply the substantive law of the relevant state in diversity cases. Prior to the 1938 adoption of the Federal Rules of Civil Procedure and the Supreme Court's decision in Erie, federal courts applied a federal general common law even in diversity matters, a practice Erie repudiated. Unlike the federal courts, whose subject matter jurisdictions and proper venues are established by the Constitution and statutes rather than rules of procedure, questions of jurisdiction and venue in California courts are rooted in the California Constitution, but elaborated by the California Code of Civil Procedure, subject to the limits imposed by the United States and California constitutions. At the helm of the California judiciary, the California Supreme Court has the last word on disputes arising solely under California law. It exercises supreme authority within the state system to interpret and apply the law, thereby ensuring uniformity among California courts, as well as binding in state federal courts required to apply California substantive law under the Erie Doctrine. When the California Supreme Court instead resolves a question of federal law, its decision binds only California's lower courts. It does not bind the federal courts sitting within California or the courts of any other state. The California Supreme Court also exercises continuing personal jurisdiction over appellants and respondents on review. Once litigants invoke the appellate process by submitting appeals or responses from lower California courts, personal jurisdiction over them remains settled, consistent with due process requirements. Under Article 6, Section 10 of the California Constitution, the Supreme Court possesses original jurisdiction in proceedings for extraordinary relief. This constitutional authority is explicitly limited to causes for writs of mandamus, prohibition, and habeas corpus, addressing the legality of confinement, as well as certiorari, styled as a writ of review under California statutory law. Under Section 12, the court holds appellate jurisdiction over all matters it transfers to itself from the courts of appeal. It also exercises immediate appellate jurisdiction in all cases in which a judgment of death has been pronounced. Furthermore, the California Supreme Court exercises original and, in certain instances, exclusive jurisdiction over decisions issued by specified governmental administrative agencies, such as certain rulings of the Public Utilities Commission, while review of most other administrative decisions proceeds initially through Superior Court proceedings. Below California's Supreme Court are the California Courts of Appeal, organized across the state in 6 appellate districts. The Courts of Appeal are constitutionally limited to reviewing appeals taken from appealable orders and final judgments issued by their subordinate superior courts in both civil and criminal cases. The operative term is appealable, since there exists no absolute right of appeal from every trial court decision. For example, most interlocutory, non-final, orders are not directly appealable and instead require writ review, except for death penalty judgments, which are appealed directly to the California Supreme Court. The final judgments in felony and juvenile matters, family law matters, probate cases, and unlimited civil cases, that is, those actions whose amounts in controversy exceed $35,000, can all be reviewed by the California Courts of Appeal. In brief, the California Courts of Appeal have appellate subject matter jurisdiction over appeals from unlimited civil and felony causes that were within the original jurisdiction of the superior courts, except for death penalty cases and other matters expressly reserved to the Supreme Court or otherwise prescribed by statute. The Courts of Appeal acquire fundamental jurisdiction over the action once a timely notice of appeal is filed in the superior court from which the appeal is taken. Their authority to review the case is thus predicated on the trial court having properly exercised jurisdiction over the parties and the subject matter below. Direct appeals from California trial courts are decided on the court reporter's transcript of testimony, the clerk's transcript of filed documents, the parties' briefs, and oral argument by counsel. Appeals proceed upward through the California judicial system to the highest state court empowered to adjudicate them. They do not enter the federal system by way of appeals to the federal district courts. If they were to reach the federal courts on direct review, it would be through a petition for writ of certiorari to the United States Supreme Court, though state criminal defendants may subsequently seek collateral review in federal district courts via writs of habeas corpus. Once decided by the California Courts of Appeal, published opinions appear in the California Appellate Reports and are available to all superior courts statewide. Though there is no horizontal stare decisis, binding one appellate district or division to the decisions of another. As for their original jurisdiction, the California Courts of Appeal may entertain and summarily resolve writ petitions. They do so by issuing trial courts the same sorts of writs, available from the California Supreme Court. Writs of mandamus, prohibition, and habeas corpus. These writs provide extraordinary relief in circumstances such as discovery order challenges or the disqualification of trial judges, when direct appeal is unavailable or inadequate. Direct appeals are taken from the California Superior Courts. Under Article 6, Section 4 of the California Constitution, the superior courts are the trial courts of original jurisdiction. They exercise original jurisdiction over both unlimited and limited civil cases, and that jurisdiction is statewide in character, not confined to any single county or vested exclusively in any unique division, department, or judge. The distinction between unlimited and limited jurisdiction derives from the historic division between superior court litigation and former municipal court litigation. Both categories now reside within the original and fundamental jurisdiction of the superior courts. Unlimited subject matter jurisdiction encompasses actions for declaratory relief, injunctive relief, family law matters, juvenile proceedings, probate proceedings, and the full range of other civil and criminal matters not expressly withheld. The superior courts are thus empowered to resolve all justiciable legal disputes except those committed by law to the exclusive jurisdiction of the federal courts or to specific administrative agencies, such as the Workers' Compensation Appeals Board or the Public Utilities Commission. More particularly, the subject matter jurisdiction of the superior courts extends to public offenses classified by statute as infractions, misdemeanors, and felonies. The superior courts also possess jurisdiction to grant extraordinary writ relief in the forms of mandamus, prohibition, and habeas corpus, as well as authority to make special immigration juvenile findings concerning the custody and care of children under the Federal Immigration and Nationality Act. Most notably for civil litigation, the superior court's subject matter jurisdiction over civil actions turns on the amount in controversy, the value of the monetary relief sought, exclusive of attorney fees, interest, and costs. A civil action in which the amount in controversy exceeds $35,000 is classified as an unlimited civil case. A civil action in which the demand, exclusive of interest, or the value of the property in controversy amounts to $35,000 or less, is classified as a limited civil case. The Superior Court likewise treats special proceedings for forcible entry, forcible detainer, or unlawful detainer as limited civil cases when the total amount of damages claimed is $35,000 or less. In limited jurisdiction actions, the Superior Court possesses incidental authority to issue preliminary or temporary injunctions, though not permanent injunctions, to appoint receivers, and to preserve records or property. Within the original and limited jurisdiction of the superior courts lie the special proceedings known as small claims actions, to which every superior court assigns a dedicated courtroom or division. The small claims court or division is not a hierarchically inferior court, but rather a judicial officer or set of judicial officers assigned to conduct these special proceedings. In them, minor civil disputes are resolved through informal, Simplified and low-cost procedures. The most common small claims actions are those brought by natural persons, whose demands are statutorily limited to $12,500, and those brought by corporations or other business entities, excluding sole proprietors, who retain the natural person limit, whose demands are limited to $6,250. Natural persons are therefore jurisdictionally limited to total principal damages of $12,500, while legal entities are capped at $6,250. These subject matter jurisdictional limits cannot be evaded by splitting a single dispute into multiple small claims actions. No plaintiff except a local public agency may file more than 2 small claims actions demanding more than $2,500 in any calendar year, regardless of venue. There is no limit on the number of claims demanding $2,500 or less. For any claim exceeding $2,500, the plaintiff must file a declaration under penalty of perjury, attesting that the 2-claim limit has not been exceeded. If the amount demanded exceeds the applicable jurisdictional limit, the plaintiff must irrevocably waive the access to proceed in small claims or, alternatively, commence the action in the limited civil division of the Superior Court. The subject matter jurisdiction of the Small Claims Division also extends to certain forms of equitable relief, such as rescission, restitution, reformation, or specific performance, in addition to or in lieu of monetary relief, and to injunctions or other equitable remedies only when a statute expressly authorizes the Small Claims Court to grant such relief. In small claims proceedings, plaintiffs have no right of appeal. Only defendants, or parties against whom a counterclaim has been adjudicated, who appeared at the initial hearing may appeal. A small claims defendant who failed to appear is limited to filing a motion to vacate the judgment. A small claims appeal is not true appellate review, but a trial de novo, a complete new evidentiary hearing conducted in the broader Superior Court. The judgment rendered by the Superior Court on that de novo trial is final and not subject to further direct appeal. For most litigants, the de novo appeal, when available, or a motion to vacate judgment constitutes the primary post-judgment avenue for challenging an unfavorable outcome. Nonetheless, the Small Claims Court is treated as an inferior tribunal under Code of Civil Procedure Section 116.798 when it, or the Superior Court on trial de novo, has exceeded its jurisdiction, failed to perform a required duty, or acted unlawfully in a manner not adequately remediable through ordinary statutory processes. Section 116.798 does not create a right of appeal. It merely authorizes the discretionary intervention of designated higher courts through extraordinary writ proceedings in truly exceptional cases of jurisdictional or legal error, without undermining the streamlined, limited review character of small claims actions. Writ proceedings challenging pre-judgment acts of the Small Claims Division may be heard by a single judge assigned to the Superior Court's Appellate Division, whereas challenges to post-judgment enforcement orders may be heard by the Appellate Division itself. Both may also be heard by a California Court of Appeal or the California Supreme Court. Writ proceedings challenging acts of the broader Superior Court in a small claims appeal, however, may be heard only by a California Court of Appeal or the California Supreme Court. Given these numerous forms of general unlimited and limited subject matter jurisdiction, including small claims proceedings, a Superior Court is obliged to satisfy itself that it possesses subject matter jurisdiction over any pending dispute. If the Superior Court lacks subject matter jurisdiction, the defect cannot be waived by the litigants. That said, by virtue of its constitutional designation as a court of general jurisdiction, a Superior Court is not deprived of subject matter jurisdiction merely because the parties have agreed to submit their dispute to arbitration. Neither is a California Superior Court deprived of personal jurisdiction over litigants when it exercises that jurisdiction on any basis not inconsistent with the Constitution of the United States or the Constitution of California. In accordance with its long-arm statute, Code of Civil Procedure Section 410.10. A superior court may exercise personal jurisdiction over a defendant when process has been effectively served and the exercise comports with either traditional bases of jurisdiction or the constitutionally mandated minimum contacts with the forum such that maintenance of the suit does not offend traditional notions of fair play and substantial justice. A California Superior Court may therefore assert personal jurisdiction over a non-resident defendant who has not been served with process within the state, provided the non-resident has such minimum contacts with California that the assertion of jurisdiction satisfies due process. Even where minimum contacts exist, however, the Superior Court must have proof that the plaintiff has served the absent non-resident defendant in the manner prescribed by California law or the law of the territory in which the defendant is domiciled. For defendants domiciled outside the United States and subject to the Hague Service Convention, the court will deem service valid if accomplished in accordance with the methods permitted under the convention, which may include the internal law of the defendant's country of domicile, service through a central authority, or in response to a letter rogatory. A California Superior Court possesses original jurisdiction over all causes falling within the scope of its subject matter jurisdiction. Like the California Supreme Court and the Courts of Appeal, a Superior Court also exercises original jurisdiction over proceedings seeking extraordinary writ relief in mandamus, prohibition, and habeas corpus. However, no ordinary trial court possesses appellate jurisdiction over another trial court. Likewise, no division, department, or judge of the same superior court may interfere with the decisions of another judge, department, or division. With limited exceptions, no superior court judge may reconsider the rulings or findings of another superior court judge. As aptly stated in Re Alberto, for one superior court judge, no matter how well intended, even if correct as a matter of law, to nullify a duly made, erroneous ruling of another superior court judge places the second judge in the role of a one-judge appellate court. Only the appellate divisions of the superior courts exercise appellate jurisdiction. Because each superior court includes an appellate division typically consisting of 3 or more judges, the superior court exercises appellate jurisdiction over limited jurisdiction actions, limited jurisdiction unlawful detainer actions, and traffic infraction or misdemeanor prosecutions. Rulings of the appellate division, in turn, are not appealable as of right to a higher reviewing court. Instead, the Court of Appeal holds discretionary authority to transfer such a case to itself for review, but only if transfer is necessary to secure uniformity of decision or to settle an important question of law. Similarly, decisions or writ rulings issued by the appellate division are not subject to direct appeal. They may be reviewed by the Court of Appeal only upon a petition for extraordinary writ relief. In any event, once a notice of appeal is filed in a case, the Superior Court loses jurisdiction to make any orders affecting the judgment, subject to dismissal by the appellant or final disposition on appeal. Jurisdiction revests in the Superior Court only when the reviewing court issues a remitter remanding the case. The revested jurisdiction, moreover, extends only to those issues on which the reviewing court has permitted further proceedings. The Superior Court may not expand the scope of the remand to encompass matters outside the remitter. This limitation follows from the jurisprudential principle that courts of original jurisdiction, such as the Superior Court, must accept the law as declared by courts of appellate jurisdiction. The Superior Court therefore lacks any authority to disregard higher court decisions with which it disagrees. That said, the Superior Court is the singular and comprehensive California State Trial Court. It is the exclusive court of first instance for adjudicating all civil and criminal cases that the California appellate courts are not authorized to hear, and that have not been removed to federal court or explicitly assigned by statute to executive branch administrative agencies, such as cases regarding workers' compensation insurance, unemployment insurance, and government regulations. This exclusivity is not, however, an inherent attribute of the Superior Court. That is, Unlike original and general or limited subject matter jurisdiction, the notion of exclusive jurisdiction is not expressly ascribed to the Superior Court by California law. Rather, the Superior Court holds exclusive authority to adjudicate a broad range of disputes only because no other state or federal court is empowered to oversee their initial litigation. The court's exclusive authority is not a function of jurisdictional principles, but a function of the California judiciary's hierarchy. That exclusive authority is exercised within the Superior Court through specialized divisions that handle unlimited jurisdiction civil matters, limited jurisdiction civil matters, and criminal matters, as well as through departments addressing family law, probate, unlawful detainer, and traffic infractions. These are colloquially and misleadingly referred to as the civil courts, criminal courts, juvenile courts, family law courts, and probate courts. But there are no separate courts possessing distinct jurisdictions within the Superior Court. There is in every county a single Superior Court, consisting of one or more judges. Consequently, a judge sitting in a family law department possesses precisely the same fundamental jurisdiction as a judge sitting in a complex civil litigation department. Still, the rule of jurisdictional priority governs the Superior Court's internal operations. Once a particular department is assigned a matter, it acquires exclusive authority to act on that matter to the exclusion of all other departments. A family law department, for example, holds priority of jurisdiction over the division of community property in a marital dissolution proceeding, and any order issued by another department of the same Superior Court that interferes with that property division is jurisdictionally void. It is also true, as already noted, that California's superior courts often possess concurrent jurisdiction with federal courts, with executive branch administrative agencies, and with other California trial courts. Superior courts possess concurrent jurisdiction over claims arising under federal law or the laws of sister states, unless federal law explicitly restricts jurisdiction to federal courts, thereby preempting California litigation. Whether federal preemption implicates the Superior Court's subject matter jurisdiction depends on the nature of the preemption. When federal law dictates that a dispute may only be litigated in a federal court or administrative agency, known as complete or choice of forum preemption, it completely divests the state court of fundamental jurisdiction. Because subject matter jurisdiction cannot be conferred by consent or waiver, a defendant may challenge a court's concurrent jurisdiction on these grounds at any time. At the pleading stage, before trial, or for the first time on appeal. If, instead, federal law merely requires the state court to apply federal rules to the dispute, known as ordinary, conflict, or choice of law preemption, the Superior Court retains concurrent subject matter jurisdiction over the case. Under these circumstances, the federal preemption is choice of law preemption, which operates as an affirmative defense that can be waived if a defendant fails to timely assert it. When a statute endows an executive branch administrative agency with original jurisdiction over a dispute, a superior court cannot exercise concurrent jurisdiction until available administrative remedies have been exhausted. Although the court may possess fundamental jurisdiction over the subject matter and the parties, the claim is not ripe for judicial review absent exhaustion. Any premature judicial action would thus exceed the court's proper authority and would ordinarily require dismissal or abatement of the proceedings. By contrast, if no statute grants the agency original jurisdiction, the Superior Court possesses concurrent jurisdiction over the dispute. In such cases, the court may, in its discretion under the primary jurisdiction rule, adjudicate the dispute itself or stay its proceedings and let the agency apply its specialized expertise. When two California superior courts perfect fundamental jurisdiction over the same dispute and litigants, judicial precedent has applied the rule of concurrent but exclusive jurisdiction. Pursuant to this rule, the court that first assumes fundamental jurisdiction over the dispute and the litigants acquires priority in adjudicating the entire controversy. This priority may be highlighted in the posterior court by way of demur or answer, which constitutes what is called a plea in abatement. A plea in abatement can serve to abate, or stay, the later filed action until the first is disposed. It must be noted, however, that this rule of intrastate court priority does not govern identical and simultaneously litigated state and federal actions. Actions arising from the same core facts may be simultaneously litigated in both a California Superior Court and a federal district court. Under the circumstances, neither court possesses exclusive jurisdiction, and neither may interfere with or restrain the proceedings of the other, although each may, in its discretion, abstain from exercising jurisdiction over its respective case. As for proper venue, it is the California county of the Superior Court where a legal dispute should be adjudicated by either a judge or a jury. The proper venue for litigating ordinary civil actions is normally the Superior Court in the county where the defendant or defendants reside at the commencement of the action. If the action involves injury to person or personal property, or death from wrongful act or negligence, the proper venue is the Superior Court in the county where the defendant resides or where the injury occurred. For a breach of contract action, the proper venue is the Superior Court in the county where the defendant resides, where the contract was signed, or where the contract was to be performed. Actions involving real property should be filed in the Superior Court of the county where the real property that is the subject of the action is located. In a proceeding for dissolution of marriage, the proper venue is the Superior Court of the county where either the petitioner or the respondent has been a resident for the 3 months prior to commencement of the proceeding, subject to the separate 6-month California residency requirement for entry of judgment under Section 2320 of the California Family Code. Regardless of where an action is commenced, defendants may move the court for an order transferring the matter to another county. The court may grant a motion for change of venue if the original venue is improper. If, in a marital dissolution action, the respondent resides in another county and the ends of justice would be served by the transfer, or if there is reason to believe the defendant may not receive an impartial trial. Motions for change of venue are governed by Sections 396B and 397 of the California Code of Civil Procedure, which only applies to transfers from one county to another. A change of the place of trial from one location to another within the same county is not a change of venue, but rather a change of forum within the venue. The forum in which a case may be commenced, and any alternate forums within that venue, are determined by the local rules each Superior Court promulgates. For example, Los Angeles Superior Court Rule 2.3 currently mandates that unlimited jurisdiction civil tort actions be filed in the judicial district within Los Angeles County, where the incident arose, with the appropriate judicial district determined by use of the Los Angeles County Superior Court's online filing locator. Rule 2.3 permits optional filing of contract actions in the county's central judicial district, or where contract performance was required by an express contract provision, or where the defendant resides. Rule 2.3 also sets forth in detail the mandatory or optional filing requirements for all other types of lawsuits and criminal prosecutions, as well as the specific rules governing transfer of actions within the county. Comparable local rules are promulgated by all other California Superior Courts and should be consulted to determine the proper forum or alternate forums within a given venue. In conclusion, the general concepts of jurisdiction, venue, and forum assume distinct, system-specific applications within the federal court and the California state court hierarchies. Mastery of the distinctions is indispensable for effective litigation. Missteps can result in dismissal, remand, transfer, or jurisdictionally void orders, while strategic forum selection can significantly shape procedural efficiency, applicable substantive law, and ultimate outcomes. Whether in federal or state proceedings, a clear grasp of these applications upholds the rule of law, respects sovereign boundaries, and ensures that justice is administered in the proper court, at the proper time, and under the proper rules.
Final reminder. The contents of this video are for educational and informational purposes only. They do not constitute legal advice and are not a substitute for personalized guidance from a licensed attorney, familiar with your specific facts and circumstances. No attorney-client relationship is formed by watching, liking, commenting, subscribing, or communicating through this channel. Laws change over time and vary by jurisdiction. Do not act or refrain from acting based on anything in this video. Seek advice from a qualified professional in your jurisdiction. The creator disclaims any liability for loss or damage claimed to result from reliance on this material.